Welcome back. This is the Weekend Report. I am Master Mposwa. The Constitutional Court has overturned a High Court ruling that found part of the Recognition of Customary Marriages Act to be unconstitutional. Now, this week, the Apex Court upheld the law, making it clear that married couples cannot change their property arrangements once a customary marriage exists. Now, the case was centered around a dispute on a section of the Act which deals with situations where spouses marry under customary law and later marry under civil law. The High Court had previously ruled that this provision was unconstitutional because it appeared to allow couples to change their matrimonial property system simply by signing a written agreement without legal oversight, which could unfairly prejudice economically weaker spouses, commonly women, and amount to arbitrary deprivation of property. So let's speak now to Director at Dubazana Attorneys, Nthabiseng Dubazana. Thank you so much for your time. What seems to have been portrayed to provide clarity around this very contentious issue looks like it's only caused more confusion. So let's just start with the basics. Can you explain what is happening?
Good morning. Thank you so much for having me. So, yes, I'm in agreement with you. I was actually having a discussion with a colleague of mine who's actually a presiding officer and magistrate, saying we feel like the court hasn't actually dealt with anything per se. So the section 10 subsection 2 of the Recognition of Customary Marriages Act says that after section 3 has been concluded in that you have entered into a customary marriage, then you can, by agreement with your spouse, then change the marital contract or the marital regime to be whatever it is that you wish it to be, which now goes against the Matrimonial Property Act as it stands. So the Matrimonial Property Act says you need to choose one of the three marital regimes, either in community of property, out of community of property without accrual, and then out of community of property with the accrual system applicable. So, and in order for you to change from one to the other, you have to do what we call a post-nuptial, but in our terms in law, in South African law, I beg your pardon, it's a section 21 application of the High Court. Ne? So the section that Murumwagai AJ in the High Court was saying is unconstitutional was based on exactly this history that I'm giving you, to say how is it that every other marriage in terms of civil law, you have to go through the court channels and thus protecting any spouse that needs protection as a direct result. But when it comes to customary marriages, nah, it's okay. Don't go that route. Customary law is not that serious. That's what he's basically saying in his judgment, to say by virtue of the existence of section 10 subsection 2, it's signifying the insignificance of a customary marriage, which is therefore unconstitutional. And then the Constitutional Court went against all of that. In its judgment, I read they went through the history of how section 10 subsection 2 came into being, how it is, back in the day when Black people could not get married unless it was civilly, the Black Administration Act, all of these things that were repealed. But this particular section was then put in a way that, that doesn't make, that doesn't clarify the stance, especially of Black women,
Sure.
Who were the ones who were marginalized a lot back in the day. But now it lingers. Nothing has been dealt with it. So the court is saying we as practitioners and other presiding officers are not reading it correctly. We are interpreting it incorrectly because the legislature did not intend for it to be read in that way.
Maybe they need to write it in a way that we can read it and understand it correctly. And I have to agree with the sentiment that it seems, but I mean, it's quite obvious that customary marriages are not taken seriously in this country. Why are we still following the Dutch law system and also the customary law system? Because there are many areas where these two systems conflict.
So our law, as you correctly put it, stems from Roman Dutch law. And then we had our own customs and traditions. So our constitution, as brilliant as it is, when it came into play, it did not repeal anything that came with the apartheid system. There are so many laws that are still in existence that were in 1947, 1970 something, all of these things, they're still in existence. But unless somebody comes and brings it to court and challenges it, it remains in existence. So that is why we are juggling both the Roman Dutch law, the common law, and customary marriages. And our constitution protects our customs to be, codified, which is not the case. Our customs are not codified. So we don't have a codified direction.
What do you mean by codified?
Put down in writing. So you are specifically saying in the Sesotho culture, or when you get married, Mahadi does this, that, and the other, for example.
Sure.
If I, for example, in the Kingdom of Lesotho, there is Mulawale Rotodi, which deals with customary law, and then there's the legislative law. So if you choose to live in terms of customary law, then Mulawale Rotodi governs your life, and that is codified. It is put in writing how it's supposed to be done. Mona, in our country, it's not like that, unfortunately.
Yeah, and I want to expand a little bit on that, because I mean, during a Lobola negotiation, for instance, and during the Lobola process, some families consider Lobola to be marriage, other families consider it to be an engagement, but whatever the families agree is what will be true for the family. But Hosalang, I get it. It is documented, right? So every family member will list their names, their minutes, everything. Isn't that a legally binding contract?
That is where the main bone of contention is, because I think I've been saying this for over 7 years, if not 8 years, to say, once you go into these negotiations, you must know that that piece of paper is your contract. You can't now go and do an ante-nuptial, because ante means before you enter into something. If you want to change a marital regime, you have to do a post after you've done something. And the amount of flack I've gotten on this for so many years, and now the Constitutional Court has confirmed to saying you cannot do anything like that. So now here's the problem. In Sesotho, Nthabiseng you do it in X way. In isiZulu, it has to be done a certain way, etc., etc. So now the Recognition of Customary Marriages Act, Section 3 says you have to be of age, which is 18 and above, give consent and celebrate in terms of custom. It doesn't clarify if you pay mahadi in full or if it was just a lunch or all of these things.
Yeah.
So now our customary marriage is not dealt with only the act. You also going into case law. Case law has also merged all of this, because somebody from 40 years ago went and destroyed a marriage 6 years because she came with that piece of paper and said, this is my husband, and the court recognized her. So now, these are the things that people need to know.
Right. So now Nthabiseng, what happens to people who are customarily married? And I get it, the Marriage Act stipulates that you have to register your marriage within 3 months of being married. But even if you don't, it doesn't disqualify your marriage, which is also just a contradiction on its own. But what happens? I mean, there are many viewers watching this right now wanting to know, okay, I married customarily, but because I've not registered my marriage, I was planning on taking an ANC, an antenuptial contract, because you have to do it before you actually register the marriage. But does that mean now we are automatically married in community of property and there's nothing we can do about that?
No, you can do something about it. Yes, you're automatically married in community of property. So if you want to change it, you have to approach an attorney, and we approach the High Court and make an application in terms of Section 21 of the High Court. I get it. And in that Section 21, we do it as if we're advertising a deceased estate. Remember, when somebody dies, we need to advertise to creditors and so that everybody can come and claim. So now, when you are now changing your marital regime, we have to advertise that. Your creditors have to say whether or not they're objecting to you changing marital regime. Why? Because when you're married in community of property, if I enter into debts for days that I don't tell you about, by the way, they bind you nonetheless. Now we are saying we want to marry out of community of property. They're going to say, Nthabiseng ha patale hantle. You know what I mean? So we're going to
go responsibilities.
So now if she changes its marital regime, it means I can't go after Maschaba, who looks like she's more liquid versus Nthabiseng. So therefore we're objecting. So these are the things that people need to take into consideration before you make a decision to marry.
Right. And now, all right, so let's talk about this now, because now I'm seeing all kinds of debate on social media with people saying that, but confirm if this is true or not, right? That now, when you divorce your customary spouse, you have to divorce through the courts and get a divorce
100.
decree. But how does that make any sense? Does that mean that if a person had been married to someone else before, and you don't have a divorce decree, that technically that there are many women out there who could be having 2 or 3 husbands?
You hit it right on the head. So if you had paid Mahadi or Lobola for somebody, and then you guys separated, and then the families agreed and a letter was written that you guys are good, you've parted ways, you're not divorced. The example that I gave you just now, it was a deceased estate situation. Nthabiseng was married 6 years with the deceased, civilly so, but Maschaba was married to the deceased 40 years ago, customarily. So when he then passed, Maschaba came with her piece of paper, Yamahadi, to say, we never divorced. This person is actually my person. And Nthabiseng then challenged this. At the end of it, it was in the Bombela High Court. At the end of this, Maschaba was then recognized as the wife of the deceased from 40 years ago.
Hey.
And this one, the civil one, was then declared to not, the marriage didn't exist.
Null and void.
Exactly, ma'am.
We're going to have to leave it right there. All I can say is this is a mess. It's a mess. But nonetheless, thank you for taking the time to educate us. That was director at Dubazana Attorneys, Nthabiseng Dubazana. Let's get our affairs in order.